of State recently proposing some new guidelines and new regulations, in fact, to the State Board of Real Estate, and on June 24th they went forward. And I think to say it's two key areas, probably more than any other, have caught our attention and have raised some controversy through our local boards, saying that these current regulations perhaps don't appreciate developments in the industry. One of the requirements in these proposed regulations are that the name of the broker be placed in all advertising 25% larger than the name of any associated or affiliated licensee, such as the salesperson or the associate broker. Under the current guidelines, the name of the salesperson or associate broker can be no larger than the name of the current broker. It's an equivalence current in the guidelines. But these proposed regulations provide for a predominance, a 25% larger technique. And I think if you reflect upon the advertising you might use with respect to newspaper advertising, even your websites, advertising on the side of vehicles, signs, and the like, this kind of disproportionate size requirement raises a significant issue. In other states around the country, there are rules that say that the name of the broker simply needs to be clear and unmistakable. The principle that the Department of State was concerned with and the State Board of Real Estate is concerned with is recognizing the supervisory primacy of the listing broker, and the sponsoring broker has the responsibility to supervise the affiliated sales associates. And so this question of do we need that spatial relationship, that size, that type size differential to reinforce the obligation of the sponsoring broker for those affiliated with that particular firm. Another issue that's addressed in these regulations for the first time is the question of teams. Now, you know, New York State requires that you only advertise yourself in your official license name. And we've had this development in the industry that the branding, personal branding for our sales associates, the utilization of teams has become very important to the market effectiveness of our licensees. But teams themselves aren't a licensed legal entity. They don't have recognized status under the license law, and currently there's nothing in regulation or even guidelines that would allow the utilization of teams. There is one case pending at the Department of State presently with regard to advertising by teams, and until that case comes down, we really don't have any definitive guidance by the Department of State as to how it's going to react to teams. I think it's fair to say, though, that the teams as they stand are holding themselves out as providing a business opportunity and doing business, but the actual name that the licensees are going to do business in is the name of the sponsoring broker. In New York, we have, in the general business law, requirements for assumed business name, that you file a DBA if a legal entity is doing business under an assumed name. There's a place that you go at the county clerk's office that will tell you who, in fact, is the actual legal entity with whom you're doing business. And there's been a suggestion to try to utilize the DBA statute in conjunction with new licensing regulations to allow, then, the utilization of teams in a permissible fashion. Currently, there simply is no guidance that would tell you for sure that it's permissible to advertise your team, because that team itself is not a recognized legal entity that has a licensed status. In any event, the Department of State's proposal and the State Board of Real Estate's proposed regulation requires or provides that you can't have teams, but the team name is limited to 2 names of licensees, and you have to use the correct license name of those 2 individuals. That has presented quite a problem, I think, for an array of teams around the state, and so the suggestion has been that there be a revision of that regulation to provide for the utilization of a DBA statute in conjunction with team names that would make one place that can be ascertained who's part of that team and who's responsible for the functioning of the team. In addition to the new proposed regulations deal with telephone numbers, and the regulations essentially provide that the telephone numbers that's got to be used in advertising has to be the telephone number of the broker, the firm fixed place of the broker's office. And I think we can say that that is inconsistent with the predominant use of telephone numbers by the sales associates that would bring the phone calls directly to them, or some kind of an interactive site that would sit there and give current listing information. Essentially, the current regulations that are proposed by the State Board of Real Estate recognize the sponsoring broker's responsibility and supervisory authority. And in that fashion, with these 25% size differentials and with the requirement to put in the name of the broker and put in the broker's telephone number, we have limited, I think, in some fashion, if this proposal went forward, the flexibility that's currently enjoyed, at least by lax enforcement by the Department of State. The current Department of State regulations, again, provide that advertisements have to have the name of the broker and the telephone number of the broker. They allow, through interpretation and case law, the Department of State licensing decisions and the advertising guidelines, additional information to be provided, such as the sales associate's name, the correct license status of the sales associate, and a phone number for the sales associate. But all of these fashions in which they provide for information require that broker number, that broker name. In addition, there is proposals for sale signs, and those for sale signs in some communities have very limited spatial opportunities. They'll provide, in some communities, just for sale and a telephone number. There's a proposal in these draft regulations to provide an exception to the normal DOS requirements to say except as authorized or required by local law. And the purpose of that regulation is to allow your utilization of the advertising that's compliant with your local municipalities. Overall, I say that the Legislative Steering Committee has a mission in front of it on this next session that's coming tomorrow to look hard at these regulations. The Governor's Office of Regulatory Review has them and will be looking whether they're going to be published currently in the state register. We've been told by the Department of State that they would support either a revision of the current proposal that's pending at CORE, or even if necessary, a complete withdrawal of that proposal to bring it back and take a further look at what would be compliant with the current requirements of the marketplace, as well as the necessary kind of principled purposes that we have regulations. The reasons in New York State that we have dishonest and misleading advertising, those can be handled on a case-by-case basis. But the prescription of type size, the denial of the ability to utilize logos by teams, the requirements that we are seeing in these proposed regulations, I think, have a risk of hamstringing some of our business practices that have evolved in recent years without any kind of regulatory disagreement by the Department of State. We will bring to you at your next session the results of the pending case in front of the administrative law judge, and it will be the first guidance we have with respect to teams. Currently, teams it's kind of like speeding. You're going down the highway, everything's fine if you're not given the ticket, but we don't know for sure that the Department of State is going to allow the team advertising. We have heard anecdotal reports that there are Department of State violations that have been found and fines in the amount of $1,000 a violation for type size requirements where the team name or the sales associate names have been in advertising produced in larger type sizes than the name of the broker. The concern the Department of State has raised is the need to have accountability. They need to know what is the legal entity with whom you're dealing, and that's those contractual relationships, as we know, are with the broker. In any event, legislative steering is coming up in one more day. The legal conference of the local board council is going on tomorrow as well. We'll be reviewing these advertising regulations, and we hope to be able to come back to you at the next session with some more positive news with respect to a set of regulations that are adaptable to the business practices. It's important to have in regulations some kind of permissibility with respect to the team concept, because presently in the license law there's no recognition of the team as a legal entity. And so I would say of all the issues that are before us, perhaps the team concept is as important as any. If there's no questions, I would be happy to see any of you after the session. As I say, we have the legal conference coming up tomorrow, and particular issues of concern would be something we have